Please be seated. We'll hear argument in two cases consolidated for argument. 2977, Texas Department of Public Safety against KT. 2175, ex parte Ferris.
May it please the court, Mr. Heifel will present arguments for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The briefs in this case present essentially three different interpretations of Article 55.01c. There's DPS's interpretation, respondent's interpretation, and amici's interpretation. I'd like to begin by explaining why DPS's interpretation is correct and then address the other two interpretations. Article 55.01c provides that if an acquitted offense arose out of a criminal episode and the person is convicted of or remains subject to prosecution for an offense in that episode, expunction is prohibited. And it incorporates the definition of criminal episode found in Section 3.01 of the Penal Code. As relevant here, Section 3.012 provides that the repeated commission of the same or similar offense constitutes a criminal episode. Here, each respondent was convicted of misdemeanor DWI and was later acquitted of another charge of misdemeanor DWI. The DWI offenses are the same or similar, so Article 55.01c prohibits expunction because each respondent was convicted of one of those offenses.
Is there any temporal proximity that's necessary to consider it a repeated offense, or could there be 50 years in between the two and you'd still consider it a criminal episode?
There is no temporal proximity requirement, Your Honor, contrary to what the court in Ferris held below. And that makes sense because Section 3.011 already defines criminal episode based on a single transaction or a common scheme or plan. Section 3.012 is a distinct provision, and it contains no temporal proximity requirement, as courts of appeals have held for decades, and we've cited some of those cases in our briefs. Moving on to...
Let me ask you about the difference in the language in 5501 and 3.01. 5501 uses the word occurring, and 3.01 uses the word commission. And the legislature seems to be using those in different ways. If an offense occurs during the criminal episode, if you're subject to prosecution for it, not just convicted of it, but why shouldn't we read that occurring to mean something different from commission, in that commission would mean that you've actually been convicted of it, whereas occurring, you can just be subject to prosecution for it?
Your Honor, so that goes to the respondent's interpretation, which is that to commit an offense means to be convicted of the offense. And there are several problems with that interpretation. First, it's inconsistent with Section 3.02, the Joinder statute. So 3.02a provides that a criminal defendant can be jointly prosecuted for all of the offenses that arise from a single criminal episode, and it relies on the definition of criminal episode that's found in Section 3.01. This shows that the legislature is viewing things from a point in time before a person has been convicted. In fact,
but that says prosecuted for offenses, which seems like a different thing from committing offenses.
Your Honor, for an offense to arise out of a criminal episode, it has to be committed under either Section 3.011 or 3.012.
But it seems like the legislature in 3.02 is lifting that requirement in some ways, because they're saying it's just what you're being prosecuted for that would otherwise be covered under 3.01.
Your Honor, it is what you're being prosecuted for, but it still has to arise out of a criminal episode under 3.02 or under 55.01c. And the only way it can do that is to satisfy the language of either 3.011 or 3.012. And so in addition to the 3.02 problem, respondents...
But why shouldn't we read that as, basically that's the prosecution's theory of the case, that their theory of the case falls under either 3.011 or 3.012 if they're prosecuting you under 3.02?
That is correct, Your Honor. So the way that
it wouldn't require. It doesn't seem to exclude the idea that commission requires a conviction.
So in 3.01, as Your Honor just suggested, what it's referring to is that this is the offense at issue, or that these are the allegations against the person. And so respondent's interpretation that it equals a conviction would render Article 55.01c a nullity. And the reason is because, again, to arise out of a criminal episode, an offense has to be committed under the language of 3.011 or 3.012. But if the respondents are correct that to commit an offense under 3.01 is to be convicted of the offense, then an acquitted offense can never meet that language of 3.01, and therefore an acquitted offense can never arise out of a criminal episode. But if an acquitted offense can't arise out of a criminal episode, then Article 55.01c never applies, and it's just a dead letter. Just like the joinder statute doesn't make sense if we assume that 3.01 is talking about a conviction.
Does 3.02 make sense if your answer to Justice Blacklock's question is correct? I don't see how a 50-year gap between offenses, if that's a criminal episode, would allow Section 3.02a to work. A defendant may be prosecuted in a single criminal action for all offenses arising out of the same criminal episode. How do you prosecute someone for a 50-year gap in offenses?
So, Your Honor, 3.01 just sets out the baseline for how we have a criminal offense, but the fact that an offense arose out of a criminal episode can sort of follow an offense throughout its history. So you can't join an offense that's already been prosecuted, that's already been resolved. 3.03 has to do with sentence stacking after a person has been convicted. So the other parts of the penal code can view the criminal episode from different points in time, but 3.01 is setting out, before any of that has happened, how an offense arises from a criminal episode. So Your Honor is correct that you couldn't jointly prosecute something with an offense that's already been tried and resolved, but that doesn't change the way that Section 3.01 defines criminal
Doesn't
episode.
3.02 give us some light with which to read 3.01? I mean, it looks like the legislature's telling us that if it's the same criminal episode, then you can prosecute. If you literally cannot, doesn't that help us think, okay, we must have gone astray in our understanding of what is meant by criminal episode?
No, Your Honor, because the starting point is 3.01, what constitutes the criminal episode. And again, if we start with that and we say, well, to commit an offense under 3.011 or 3.012 means to be convicted, to be found guilty beyond a reasonable doubt, then that's going to prevent Article 55.01c.
I'm just trying to figure out what a criminal episode means. And I think that you answered as far as 3.012 goes, that the word repeated is doing the work here. And so I'd like to, that was your answer, I think, to Justice Blacklock. And if I said, I live in a neighborhood with repeated gunfire being heard at night, say, oh, that sounds like a terribly dangerous neighborhood. And I said, yes, I heard it in 1968, and then I heard another one in 2020. Is that how any normal person would understand the word repeated?
Your Honor, that's how the courts have read Section 3.012.
Which courts?
The Guidry, the case called Guidry.
Some of the courts of appeals.
Yes, Your Honor, the courts of appeals, and I'm not personally aware of any.
This is the first time this court has taken it. I don't think the Court of Criminal Appeals has given us a definition that's consistent with what you're describing, this single episode that lasts your entire life.
I'm not aware that the CCA has addressed it one way or the other, and I'm not aware that this court has addressed it. Every court of appeals that I'm aware of that has addressed it has concluded that there is no temporal proximity requirement. And again, that makes sense because 3.011 is a distinct provision, which has to do with a single transaction, a common scheme or plan.
Why can't you read 3.011 to do exactly what you just described? A single transaction, that's where they're connected or constitute a common scheme or plan. And then 3.012 says, all right, even if your lawyer can say, or a prosecutor, I suppose, could say, yeah, they're not connected to constitute a common scheme or plan, but it's something that happens quite systematic. This person is doing things, maybe even erratically, but they're repeated within a short, reasonable period of time, such that 3.02a could apply. They're repeated events that aren't otherwise connected, they wouldn't fall within 3.011. Why wouldn't that give independent meaning to 3.012.
It could, Your Honor, but the court would be reading into the statute that temporal proximity.
Well, the word episode, let's talk about that then. Does it make sense if I were to say, let's go watch an episode of this movie? You say, that was great. Let's watch the next episode. Oh, well, no, that's it. Is that the way that an ordinary person would understand the word episode? That there can only be one for your entire life? There can only be one for a program? Doesn't episodic, isn't that a word that is chosen precisely to signify something that can recur, and indeed usually will recur?
Yes, Your Honor. So both episode and repeated suggest that there are more than one, and that's built into the definition of what a criminal episode is.
But your definition is as soon as you're convicted at all, the rest of your life until your final dying breath is a single criminal episode. You cannot have another.
It's a single criminal episode, Your Honor, if the other offense that you commit is the same or similar.
So with respect to a particular kind of crime, the Court of Appeals used the example of a 17-year-old who's convicted of shoplifting, and then at age 77, she is falsely arrested as a total case of mistaken identity for embezzlement of $250,000. Sorry, Grandma. Go back 60 years, and that shoplifting offense means that you're still living in a Kafkaesque kind of way within one criminal episode that will only end with your interment into this earth in order to satisfy the statute here.
Yes, Your Honor, and I concede that in that particular situation, one could argue that the statute seems to be operating unfairly, but the important thing...
It has nothing to do with unfairness. I can imagine a recidivist. That's what some of the judges and some of the courts of appeals have said. Like, it's perfectly fair to say, nope, you get one bite at this apple, and then after that, whether you're arrested in a case of mistaken identity or not, the recidivism interests are so strong that we're never going to deprive the public of that information. Perfectly fine. What I'm trying to find out is when the legislature used the word episode, which by its very definition seems to imply something that's connected and something that's temporal and something that can be repeated, why would we read the words in a way that I can't imagine a way that would be less consonant with the ordinary word episode when there are other ways that we can read them that are more consistent with the ordinary word episode?
Well, Your Honor, again, it only takes two times, and they only have to be the same or similar.
It takes one time, because then you're arrested ever again. The 77-year-old who's arrested on a case of mistaken identity, that is the criminal episode. She's still in it.
Well, the two offenses combined create the criminal episode. So if you are arrested once for DWI when you're 17, there is not yet a criminal episode. That criminal episode only occurs or only comes into existence under 3.01 when you add to it some other offense that's the same or similar.
A charge.
When you're falsely accused of a second crime.
Right, and again, if it strikes...
But if you've been acquitted, then how can we count that as an offense for purposes of the same criminal episode?
Well, again, Your Honor, if an offense means a conviction, then the plain language of 55...
Okay, well, what if it doesn't mean a conviction, but it means a non-acquittal? Why shouldn't we treat an acquittal as meaning that it's no longer an offense?
Well, Article 55.01c presumably is doing some work. There's a situation where you have an acquitted offense, but it was committed under the language of 3.011 or 3.012 so that it arose out of a criminal episode. If I could briefly address...
I don't think 5501c uses the word committed.
No, Your Honor.
It uses occurring.
It says arose out of a criminal episode, and criminal episode is defined by 3.01. The only way an offense can arise from a criminal episode is to satisfy the language of 3011 or 3012, and each of those subsections uses the word committed.
How does it arise out of, how does that hypothetical about the 77-year-old grandma, who never actually left her house, but she was charged with something, how does that arise out of anything?
It arises out of the combination of the two offenses. So the criminal episode is defined by 3.01, and arising out of isn't separately defined, but it occurs in 5501c and 3.03. All it can mean is that the offense is part of that criminal episode, that it's one of the multiple offenses.
Doesn't it sound like maybe once you've established a criminal episode, anything else that comes from it that you've done, committed, occurring during, that would be something that arises out of, but it cannot be bootstrapping it to say, well, that false charge, in case of mistaken identity, does not itself arise out of something that started when you were 17 and you committed a shoplift. I just don't understand how the words arise out of work there.
Yes, Your Honor, it just means to be part of the criminal episode. So regardless of when they
But
were...
if it's not criminal, how can it be part of the criminal episode?
Again, Your Honor, we need to read into Section 3.01 and understanding that the legislature is saying this is the offense at issue or these are the allegations against the person. That's the only way it makes sense to talk about a criminal episode existing before a prosecution has even taken place, as 3.02a speaks of, or Article 55.01c, which is assuming the person is acquitted and yet the offense did arise out of a criminal episode. So the only way we can understand that is to say the acquitted offense satisfies the language of 3.011 or 3.012, even though the person was acquitted for it. Otherwise, we read 55.01c out of the statute. Chief Justice, I see I'm out of time, and I'd reserve time for rebuttal if there's no further questions.
Well, I think that I sort of took you away. You were about to make some other point or turning to something, and Chief, if I might just give him a chance to briefly say what that was, I'd appreciate it.
I have a question.
Yes, sir.
What happens under the department's interpretation if there are two acquittals? In other words, there's an arrest and charge for DWI, but the defendant was acquitted, and then 10 years later acquitted again. So you have two acquittals. What happens under your interpretation that says we don't take into consideration what the final outcome of the charges bring?
So, Your Honor, under Article 55.01c, for it to apply, you have to have a conviction or be subject to prosecution. If you are acquitted of the prior offense, then you won't have the conviction and you won't be subject to prosecution for that offense. And Chief, if I
Was
might.
there something else that you were trying to say when I interrupted you?
Your Honor, I was just going to address amici's interpretation. If the court would prefer for me to do that in rebuttal, then I'm happy to do that.
Take a minute and go through it if you would.
Yes, Chief Justice. So amici's interpretation is that the only way that Article 55.01c can apply is if an expunction respondent like DPS proves by a preponderance of the evidence that the person actually did the thing for which they were just acquitted. There are several problems with that interpretation as well. To begin with, it improperly shifts the burden onto the expunction respondent, and the language of Section 55.01 A and C isn't sufficiently clear to alter the baseline rule that the expunction respondent doesn't bear the burden. And we know that by comparing 55.01 to 55.02, 55.02 Section 4 in subsections A and A-22, the legislature says if the state establishes. So we know that the legislature knows how to clearly and unambiguously shift the burden in the expunction context, and it didn't do that in 55.01. And I'm happy to further discuss amici's interpretation in rebuttal. Thank you.
Any other questions? Thank you, Mr. Heifel. We'll hear from the respondents.
May it please the court, Mr. Niehaus will present argument for the respondents.
Mr. Chief Justice, Justices, good morning. I am Edward Niehaus for the respondents. The department's position is untenable because jury trial verdicts are sacrosanct, and the department's position functionally allows for the state to relitigate acquittals. Juries are the trier of fact. The facts in these cases have been determined. These offenses were not committed and are not a part of a criminal episode. The district courts were correct.
You would acknowledge that there could be acquittals that cannot be expunged, and that's the purpose of the provision
Yes.
at issue.
Yes, and that's Ex Parte Rios out of the San Antonio Court of Appeals is a perfect example. There you had a defendant that had multiple crimes of violence, 5 prior convictions for crimes of violence, was acquitted of an assault public servant, and the court in that case, because of an existing criminal episode with more than 2 convictions, was not entitled to expunge those records.
So you would say it has to be the third
Correct.
go round?
Correct.
Would you agree that 5501C looks at the historical fact of the arrest of the person, not the judgment or the conviction?
No, reading 5501C to apply at the time of arrest is fundamentally incompatible with the presumption of innocence.
Okay, so then what do we do with the remain subject to prosecution clause?
That would be a scenario in which if the prior DWI sentence, if the DWI first, either was still in active probation or the sentence had not been fully discharged, if at that point they are arrested for a second, they would still be subject to some form of either supervision or prosecution for the first. So even if they're acquitted of the second, that would not be expungible. Here, both of these petitioners, both KT and NCF, had completely discharged their original DWI sentence at the time of the arrest for the second.
Can an offense occur but not have been committed? Can offense occur if it wasn't committed?
No,
I'm sorry?
no.
Then how do you deal with 5501C that says that there's no entitlement to expunction if the offense for which the person was acquitted arose out of a criminal episode as defined in 301, and then the repeated commission of the same or similar offenses in 3.01. But then it talks about the offense having occurred during the criminal episode.
Yes, the occurrence language, as I read it, Your Honor, is essentially an offense-based or arrest-based approach, such that if it occurs as part of a criminal episode, you're talking, a good example there is a possession of marijuana in the context of a DWI. In those circumstances, they would occur together. And I may have spoken overly ambitiously when I said no. I think an arrest can occur without the commission of an offense, but I don't know that an offense, I don't necessarily know.
So 5501C says that you got to have an offense for which they were acquitted. So that suggests that there can be an offense even if you're acquitted, all right? At least the way the statute's using that language. And then you've also got to have an offense for which they were convicted that occurred during the criminal episode. So that suggests that you can have two offenses that occurred, one for which they were acquitted and one for which they were convicted. But they both occurred under the language of the statute.
Yes, but that, I believe, presupposes that we get as far as the criminal episode. I don't think we ever get as far as a criminal episode because the language in 301 requires the commission of two or more same or similar offenses. And where you've got a conviction and an acquittal, I don't know that we've got the commission of an offense.
So under 5501C, the two offenses occurred, but under 301, the two offenses weren't committed.
Yes. And I think we can all agree the statute is not an exercise in legislative precision.
No question about that, but it starts with the arrest at the top. It's the arrest, records related to the arrest that we're talking about. And so it seems to me you might look at it, because it's all framed that way, you look at it as sort of a pre-trial. There is an offense, there is a commission, there are things that have happened, before you get to the acquit or convict stage that this statute seems quite concerned with. And it seems to talk about those things in terms of offenses and the commission of them, even though there hasn't perhaps been a determination one way or another. I struggle with this notion that we look at the word commission as, in hindsight, with respect to whether there was a conviction, when what we're talking about is the arrest.
Right, and the criminal episode in most of the cases is designed to stop the destruction of records that are still subject to ongoing prosecution. Where, say you have a possession of marijuana case in a DWI, and the possession of marijuana case gets filed quickly, and because of delays at DPS, the DWI gets filed a year later. If you try the possession of marijuana case and win, you can't go and destroy those arrest records with the DWI still pending because it destroys the state's ability to try the DWI. In contrast, like we have here, there's no destruction of the first DWI file. That DWI has been determined, it's been adjudicated, it's a conviction. What we have here is a separate arrest for a single offense that is entirely encompassed within the one allegation. The destruction of those records has absolutely no bearing on any kind of criminal episode going forward.
Except to the extent it indicates that a person, for example, might have trouble with refraining from alcohol and driving.
The acquittal.
I mean, the recidivism aspect of it is maybe what the statute's trying to get at.
I don't know that I don't know that I agree with Your Honor that an acquittal indicates recidivism.
Right, but if there's a pattern of conduct that the legislature says we want to make people aware of the pattern of conduct, even if there was an acquittal.
Of course.
And the question, right, is not whether you or we think that it's fair to view an acquittal as relevant to a question of recidivism. The question is whether the people keeping these records and the legislature writing the law, might have viewed it that way and might have thought there was a legitimate reason to maintain this kind of a thing as, for precisely the reasons suggested by Justice Bland.
Of course, but again, that would be at least marginally inconsistent with this court's prior holdings in RPGP, which allows for partial expunctions for arrests arising out of, for different offenses on different dates subject to a single arrest, and also with JTS and TSN, which both held that that a petitioner is entitled to expunction of records from a single offense resulting in a single arrest. And I have not been able to reconcile the department's position with JTS, with TSN, and with RPGP.
What's the strongest argument against the contention that is ably made by your friend on the other side that if we adopt your position that subsection C will be rendered largely ineffective?
Yeah, well, subsection C would apply, as I'd indicated earlier, if the prior DWI, if the first is either still in active probation, either deferred or straight, or if they're still subject to prosecution for the first.
But just to avoid the destruction of records pending prosecution?
Yes.
That's a pretty small category of what subsection C might encompass.
Yes, and these types of scenarios have been historically rare, which is why the 4 cases that have been decided, the 2 here, and then the case out of El Paso and the case out of Houston, are the first instance in which this court has been called on to address this question.
So I saw that you used that word rare, and I saw that the state referred to it as being very rare in the trial courts, in the cases that we have before us. If we reverse the judgments below, will it indeed still be rare, or will it be quite common that we're going to have refusals to expunge based on this?
I expect that if the court reverses, that the expunction statute's functionally rendered a nullity. If you want to take the extreme example, DWI is a traffic offense. If you've got a prior traffic ticket and DWI is a traffic offense, are those the same or similar? Is every person with a ticket for running a red light going to be ineligible for an expunction for every other traffic citation ever? To the extent that DPS argues that the criminal episode is lifelong, that's the logical conclusion of a reversal here.
You dispute the argument that it's lifelong?
Absolutely.
What's the best argument against the notion that repeated offenses doesn't have any temporal boundary?
It functionally reads 301 sub 1 as nullity, is if there's no way to get, if the requirement that they be prosecuted together is read out of 3.01, then you end up with a scenario where you have a lifelong criminal episode. So to the extent that a lifelong criminal episode could exist, it's inconsistent with the statutory language in 301.
Was 3.012 added later, or what did this, do you know what previous iterations of this statute looked like?
I believe, I would have to re-educate myself on the legislative history of 301 sub 2, but I believe it was the more recently amended, but it was not done terribly recently.
It looks that way. I need to look at that too, but it looks like most of what the statute is concerned about when it talks about criminal episode is the kind of criminal episode in 3.011.
Yes.
And then perhaps 3.012 is some kind of an effort to add something to the notion of a criminal episode for purposes of expunction. I don't know whether that's the case, but
My recollection of 3.012 is that it was most recently amended in conjunction with the stacking of sex offenses in 4308. I am going to caution that I'm not, in the interest of not misstating the law, that's my recollection. And I'd be happy to supplementally brief the legislative history of 301 sub 2 for you.
Under your reading of 5501C, is it correct to say that expunction is only available if there are charges for at least 3 offenses, 2 of which they must have been convicted on, and then the 3rd, they can be acquitted?
That would be consistent with my reading, yes.
There has to be at least 3 charged offenses.
In that.
Because in order to get to a criminal episode, you have to be convicted for 2, and then the 3rd one, you could be acquitted and get expunged.
It would depend on whether those are independent or concurrent arrests.
Well, no, I'm assuming they all fit within repeated under 301.2.
Yes.
Right? So if we're working under 301.2, under this idea of a criminal episode consisting of repeated commissions of the same offense, and accepting your definition of commission to mean conviction, then for there to be a criminal episode at all, you got to have 2 convictions for repeated offenses, and then it would require a 3rd one for which you're acquitted and could then get expunction. So you got to have 3 charged offenses.
Assuming they are occurring independently, yes. In that scenario, a DWI 3rd or more would not be expungible with the 2 prior convictions. A theft under 750 with 2 priors would not be expungible because of the 2 prior convictions. So repetitious theft cases are a perfect example, yes. If you've got theft case number 1 in a conviction, and theft case number 2 in a conviction, and then theft case number 3 in an acquittal, that 3rd theft case is not expungible because you've got the 2 predicate offenses for an existing criminal episode.
No matter when those offenses occurred. So if the 77-year-old grandmother had 2 shoplifting charges at convictions at 17, you would say she's out of luck.
I don't like it, but yes.
Okay.
I believe that's what the statute requires.
So you don't think repeated has any connotation other than more than 1?
Correct. Or multiple at the same
Court of
time.
Appeals cited this court's decision in Creative Oil to say, look, we have to read even defined terms through the lens of what they're purporting to define. They're a matter of public concern here, criminal episode. But I just understood you to tell Justice Bland that we can set aside the fact that episode usually doesn't last for one's entire life and just take repeated, write it all the way to the end. Is that a concession you really want to make?
It's not a concession I really want to make, but it's a concession I believe
have to make it?
that the language of the statute currently requires.
Is there? My understanding is that criminal episode is not unique to our state. It appears in lots of state laws, and of course we have to rely on the definition that our legislature gives us. But can you tell us whether there's any other state that has defined a criminal episode to last one's entire life under any definition?
I cannot, and I'm also unaware of any other state that would include an acquittal within the scope of a criminal episode.
is there any context or element of the statutory scheme besides expunction where this 3.012 type of criminal episode come into play, or whether it would matter, what we say a criminal episode means, does that matter outside of this little expunction context that we're talking about?
It could in the context of sentence accumulation, stacking of sentences, is where the offenses are tried together, accepting certain statutorily delineated exceptions. The sentences are presumed to run concurrently, but if the defendant elects to sever, to try the cases separately, they're subject to accumulation, a stacking order if they're convicted of multiple arising out of a same criminal episode. So there is an ancillary interpretation or ancillary issue where it may apply, but I don't think it would be something we'd see very often.
And it doesn't sound like that would make a difference in one of these cases where the second offense is many, many years later and they can't be prosecuted closely in time.
That's correct, yes.
Let me just try one more time to get more clarity under your view of 5501. And taking the temporal proximity problem out of the picture, if someone is charged with robbing Bank A on January 1 and Bank B on January 2 and Bank C on January 3, they get 3 charges, and they are acquitted for Bank A, but they are convicted of Bank B and Bank C, then it would be your position that they are not entitled to expunction for the charge on Bank A.
Yes.
But if they were only charged with Bank A and Bank B, January 1 and January 2, and there was no Bank C, and they're acquitted of Bank A, then they can get expunction on Bank A.
Yes.
Okay.
And the amici cite Doling v. U.S. It's in the Bennett-Haygood brief for a similar proposition. In that case, it was partly an estoppel issue related to identity, where there had been a prior acquittal. The court held under Federal Rule 404, which is largely mirrored by Texas Rule 404, that a prior acquittal would not be a basis for barring identification of the defendant in court. So, yes, even in a circumstance where there's a prior acquittal, there is still some circumstance where that evidence could possibly be used. I would like to address just briefly the burden of proof. I believe this court, as far as proving the expunction exception, I believe this court has dealt with that issue previously. I believe it was RPGP in which the court held that the department bears the burden of establishing establishing the 5501C exception to the petitioner's entitlement to expunction. I don't believe the department met that burden in the trial court in either of these cases, and I'd respectfully request the court affirm the order granting expunction in both cases, and if I may inquire of the court, if the court does so, would the court entertain a motion to recaption Ferris to use his initials?
Recaption it as how?
As ex parte CF instead of ex parte Ferris.
We'll consider that. Thank you.
Thank you.
Any other questions? Thank you, Mr. Nickhouse.
Thank you, Your Honor.
Mr. Heifel, you have 5 minutes.
Thank you, Mr. Chief Justice. I'd like to begin by addressing something that counsel for the respondents said, which is that to have a criminal episode, you need 2 occurrences, and then on the 3rd occurrence, you've got the criminal episode established, so now expunction is prohibited. The problem with that interpretation is that the acquitted offense itself, whether it's number 2, number 3, number 4, it still has to satisfy the language of either 3.011 or 3.012 to be part of that criminal episode and for Article 55.01C to apply. So no matter how many previous convictions the person has, the acquitted offense still has to be committed under the language of Section 3.01. I'd like to next turn to amici's interpretation. I understood opposing counsel just now to say that this court decided in RPGP that the state has the burden. My understanding is that I believe it's footnote 51. The court said that that was an open question, that it had not decided. Again, if we compare the language of 55.01 to 55.02, and in particular 55.02 section 4A and A-22, we see where the legislature says if the state establishes, and it clearly knows how to shift that burden. Now, amici argue that if the petitioner, if the expunction petitioner bears the burden to show that Article 55.01c does not apply, that that's an insurmountable burden because the petitioner would have to prove the negative. But the expunction statute already requires the petitioner to prove the negative in a variety of contexts. So, for example, 55.01a2, the person has to show that they did not receive court-ordered community supervision. 55.01a-3 and a-4, the person has to show that they did not previously receive an expunction under certain programs. So the expunction statute is not shy about requiring the petitioner to prove the negative.
And unless the amici are right that there's sort of a mini retrial to know whether the offense was committed, then does this burden of proof question matter very much? I mean, you're just talking about what does the paperwork look like?
It matters for one instance, and that's if the person seeks expunction under Article 55.02, Section 1, which we addressed in our letter brief. Under that procedure, no notice is required to be given to DPS, and the trial court has to sign the expunction order within 30 days of the acquittal. So if the person seeks expunction under Section 1, DPS wouldn't have the opportunity to meet any burden before the expunction order is signed. But I agree with Your Honor's sort of broader point, which is that amici's interpretation would place a heavy burden on everyone involved, on the expunction petitioner, the respondent, and the courts. A person who has just endured a criminal trial and been acquitted might have to turn right back around and essentially retry their crime, except this time at their own expense and without the protections that a criminal defendant enjoys. DPS would also bear the burden of litigating these cases and the courts of hearing them. And the key point here is that the burden doesn't have to be particularly onerous on anyone. As Your Honor was suggesting, usually these expunction proceedings can be decided on the papers. We can look at the criminal history, we can look at the arrest records, and see if Article 55.01c is triggered or not, regardless of who bears that burden.
Do you know whether the second element of the criminal episode definition was added later?
I don't know, Your Honor, if it was added later, but I do know that in the Guidry case, or Guidry from 1995, the Court of Appeals from Corpus Christi made the point that 3.012 doesn't have a temporal proximity requirement. So I know that at least since 1995, that second provision has been the law, but I'm not sure how that relates to when 3.011 was enacted.
And I'll ask you the same question as the other side. Does our interpretation of 3.012, the meaning of criminal episode, and that piece of the definition of it, would that have collateral consequences outside of this expunction statute that we're looking at?
The only instances that I'm aware of in which that definition comes into play are 3.02 and 3.03, and also, of course, 55.01c. So 3.02 is the joinder statute, 3.03 has to do with sentence stacking, and then, of course, 55.01c for acquittal expunction. The final point that I would make is there's been some discussion about what seems fair about the statute, and I'd just like to emphasize that expunction is not a constitutional right, it's not a common law right, it's only a statutory privilege, and therefore, even if it seems like maybe we would have written the statute differently, the legislature was free to define the statutory privilege however it saw fit.
Can I ask you one quick question about your argument that we must look at Section 3.01? I think this is your argument, correct me if I'm wrong, that we need to look at that divorced from the rest of 3.02, 3.03, all that kind of stuff. That's a point that you made in your briefing, right?
In a sense, Your Honor, because
55.01 says 3.01, it doesn't say the rest of it.
That's correct, Your Honor.
But doesn't 3.01 itself, the very beginning says, in this chapter, criminal episode, blah, 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 suggesting to me at least that the legislature recognizes that you can't understand what it means by criminal episode in 3.01 without looking at it in that larger context.
Your Honor, I think that just means that, except for when you have particular language like in 55.01c that imports that definition, it's just limiting the application of that to that chapter, to
Do we have any other
3.01.
cases where we refuse to look at a larger context of a code or a chapter of a code or the entirety of Texas law?
I don't believe so, Your Honor, and I'm not suggesting that the court just put on blinders. Again, 3.02A shows that we need to understand commission under 3.01 to mean something that can be understood before a prosecution has even taken place. If it must mean conviction, then we can't do that.
One last question from me. Do you have anything from other states that use criminal episode to suggest anything that we might look to? Anything particularly that would allow it to endure for the rest of this mortal life?
I don't, Your Honor. I'm not aware of any out-of-state authority on this question.
Any other questions? Thank you, Mr. Heifel.
Thank
The
you.
case is submitted, and the court will take another brief recess.
All rise.